right around the country, there are a series of similar, but not entirely identical, laws operating to enforce social distancing and ensure that the pandemic is not spread further than it has already. The laws in New South Wales are set out in amendments and also existing legislation, existing provisions within the Public Health Act. The police have the power to arrest a person who's suspected on reasonable grounds of breaching a public health order related to the COVID-19 pandemic. The police can also, pursuant to the Public Health Act, not only apprehend them, but place them back at their home, so take them back to their abode, or alternatively take them to the place where the public health order specifies that they must reside. That relates, for example, to people under quarantine who may have, for example, returned from overseas and are living in a particular place as prescribed by the public health order. Police have also the power to demand not only a person's identity, but also the place in which they live. And of course, that's relevant because police might determine that someone is flouting the social distancing and stay-at-home directions associated with the public orders of the health minister. In addition to that, there are powers under there are revised and new powers under the Public Health Act, providing that a person might be charged with breaching a public health order. In New South Wales, those penalties can range from an imprisonment, a penalty of a monetary penalty of up to $11,000, right through to imprisonment for 6 months for each individual offence. This firm is representing a number of people who've been charged in relation to those offences, and the allegations can be quite arbitrary in nature. It must be borne in mind that whilst a police officer will ordinarily issue a ticket, an infringement notice, ordering a person to pay a $1,000 penalty for a breach of a social distancing order. However, those fines are reviewable by court, and in a court setting, a magistrate is required, as a matter of law, and obviously as a matter of fairness, to ensure that the fine is proportionate to the offending, and also takes into account the monetary or pecuniary circumstances of the offender. So it's important in those circumstances that people turn their mind to whether or not they can afford to pay the fine, or whether the fine was in fact appropriate at all. It might be that they had a reasonable excuse, which is a defence to the offence, to therefore suggest that they're not guilty of the charge of breaching the public order direction, and therefore it might be worth challenging the fine or the imposition of the penalty in a court. Well, it's worth getting advice in relation to a fine under the COVID-19 laws, because the reasonable excuse provisions which excuse the commission of the offence, in other words, provide a defence or justification for doing what you were doing when the police issued the penalty upon you, can be very broad indeed. And it's the case that you may think that what you were doing was okay and justifiable. The police officer might simply disagree with you, but ultimately that's a question of law, and that's worth getting advice. If you have any concerns that what you were doing was reasonable and excusable, then you should get advice. You always have the option of simply paying the fine, but you can take these matters to court and challenge the issue of the penalty notice upon you. Further, you can also challenge the monetary penalty. $1,000 to some people is an extremely large sum of money, and in fact, it's a large sum of money to anyone for going about business as they ordinarily would on any other day. So you've got the opportunity to take the matter to court, and it's worth getting some advice as to whether or not you had a reasonable excuse for doing what you were doing, an excuse that you need to show, but an excuse nonetheless that might be reasonable.